Kia ora. This is a discussion about the legal obligations of the handling of information by public bodies. The critical act in relation to dealing with information is the Official Information Act, which passed in 1982. This is the primary statute, the primary act that governs the handling of information by public bodies, and it replaced the old Official Secrets Act. And that was a really radical change in the way that the law set out the handling of information by public bodies. Under the Official Secrets Act, the aim was effectively to try to restrict public information, and it criminalised the release of much of it. In contrast, the new Act, the Official Information Act, establishes the opposite sort of principle. In Section 5, it establishes the principle that information shall be made available unless there's good reason for withholding it. Almost the complete opposite. Part 1 of the Act sets out the basic principle of availability, and it also, so basically it says that you provide the information unless there are grounds for withholding it, and it sets out what those legitimate grounds are for withholding it. So that includes a range of different things that are set out in statute, such as undermining the right to a fair trial, endangering somebody's safety, prejudicing national security, breaching a person's right to privacy, and so on. So essentially, you provide the information unless the providing of it meets one of these tests, and then you have legitimate grounds for withholding the information. Part 2 of the Act sets out the process of these requests for information. It sets out who can request information, of whom these requests can be made, how requests can be made, and how those who receive the requests should act upon those requests. So I thought I'd just go through these in turn. Who can ask? Well, essentially anybody can ask, and anybody also includes corporate entities. So any person or organisation who is a New Zealander or who is living in New Zealand is entitled to request information. Who can they request this information of? Well, there's a broad category of public entities that can be asked for information, and that broad category includes a group that are known as organisations. And in the schedule of the Act, organisations includes a whole list of different sorts of institutions and agencies and so on, and they specify also schools. Technically they specify the boards of trustees, since the boards of trustees are the board of trustees is the sort of formal legal authority for the school. How can requests be made? Well, they can be made in pretty much any form, actually. Normally they're made in writing, but they don't have to be in writing. Usually people requesting information know they have the right to, and they might cite the Official Information Act, but they don't have to cite the Act. And also they don't need to give any reason for wanting the information. They simply request the information, and when that request comes, it needs to be met. There's actually a website that was created by somebody who ran these OIA requests by a whole lot of schools in New Zealand, and discovered that the vast majority of schools simply did not comply with requests. It was basic requests for information, and almost all of them were asking for, why do you want this? What are you going to do with it? All of those sorts of things, and didn't realise that Actually, if the requests come in, you are obligated to provide that information unless there's a reason not to. The requests are to be met within 20 working days. It's effectively 4 weeks. But there are exceptions to this too. So you can get extensions of time. But where you do want an extension of time, you need to advise the person who's requested the information that you want this extension of time. You need to give reasons for wanting some extra time, and again, these grounds need to be reasonable. You need to advise how much longer you expect this will take, how much more time you need, and you also need to advise in that communication that you're helping yourself to an extension can actually be appealed, so they don't have to just accept this extension. They can appeal your decision to give yourself an extension of time. And if there was that appeal, that's where people might look at whether the grounds for an extension of time were reasonable, for example. There is a possibility for charging for providing information. Where there's a large amount of information that's being requested, or where people are wanting it urgently, the person receiving the request can charge for this information, but this charge must be within the bounds of reasonable charges. You can't be making a surplus off it. Another thing worth mentioning is that among the legitimate grounds for refusal is that meeting the request would require substantial collation or research. So you aren't obliged to conduct some big research project amongst your own information in response to an OIA request. You're required to hand over documents and information where they exist, but you don't have to conduct some big operation. So if what you're being asked to would require that, then that can be grounds for refusing the Official Information Act request. However, the Act also states that if you are going to refuse a request on the grounds that it would require substantial collation or research, you need to have first turned your mind to whether you could still meet this request if you got an extension of time or if you charged a fee for the time that was required or whatever. Information and that's being sought can be omitted, and elements of it can be deleted. So you can give a partial provision of information. However, if you do decide to delete things, bits of documents, or omit certain documents, this needs to be for legitimate reasons, same as an outright refusal, and you also need to identify where these deletions and omissions have been made. You can't just neglect to provide something. You need to say, well, this is included in the information that you've requested, but I'm not going to give you this document or this part of a document, and this is the reason why. You're not allowed to muddy the waters here either. No yes minister obfuscation is permitted. So if an OIA request is made, the organisation or institution or agency of whom that request is made does have a positive obligation to assist the person who is seeking the information. You're not allowed to kind of hide behind some technicality about how the request was made or or that there was something very similar to this, but you didn't exactly ask it in the right way. There is a positive obligation in the Act for organisations of whom information is requested to assist the person to find what they are seeking, and also to refer them on if this is information that you don't have, but that you are aware that some other organisation does have. Then you have an obligation to refer that request onto that organisation, or at the very least advise the person asking it that this might be a source of where they could find their information. Appeals, essentially, all of these decisions, if you want to challenge, if anybody wants to challenge the substantive decision or the procedural decision or any element of it, or bits that were refused or whatever, then the procedure for that in relation to the Official Information Act is to lodge an appeal with the Office of the Ombudsman. So the Ombudsman then has the power to review any or all of these decisions related to a request and can instruct the organisation that's being asked the information to provide that information. There are a number of restrictions on that, but they're not really related to educational institutions. They're primarily things to do with national security, where there are sort of blanket bans where the Ombudsman isn't allowed to override issues on those sorts of questions. But that's essentially the way that the Official Information Act operates, and the obligations of educational institutions to act in response to Official Information Act requests.